Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by 1 billion by billion is holding up half the sky. Raise your hand if you're ready and willing. If you know it's time for a girl on time. It's time for a girl on time. It's time for
Hello, 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 everybody, and happy birthday to Music 72. Happy birthday. Sorry, I'm trying to take a pill. That's a good time for a med check, ladies and gentlemen. Med check, med check, med check. That means if you take medicine, think about taking that medicine and just get it all in your head. Music, did you want a song a little bit later? You can think about it. I want to make dinner tonight pretty early, so that's why we're going so early. So, now that we've got that out of the way, we are going to Texas. We are seeing a judge who we have seen before, but is I don't know. She gives me Judge Old Lady vibes. I would love to hear what you guys think. I've heard she's being a bit of a bitch during this this docket, but I haven't watched it myself yet. So let's watch together. Also, please hit the like button, subscribe if you're not already subscribed, and leave a comment if you're watching afterwards. I would love to hear from you. Seriously,
Good afternoon, everyone.
Sam. Oh my God. Right. She's just like right there. I wasn't expecting you to start so early. Oh, geez. Okay. I think this court judge is 3 hours west of you, Officer Porkchop. Hi, Hector. Yeah, she's in Texas. Texas is a big state. Thank you. This is what I like. Oh my goodness. The green screen took away my stomach there for a minute. This is what I like to call my Star Trek shirt because it's like very Star Trek-y, but anyways.
Proceeding is being live streamed on YouTube, consistent with the open court's provision of the Texas Constitution. If any of the parties have an objection to the live stream, kindly bring up your objection to Judge Eiserloh. With that being said, the 455th District Court is now in session. The Honorable Judge Eiserloh presiding.
All right, good afternoon, everyone. It's Judge Eiserloh here of the 455th Civil District Court. We are here in cause number, I believe on the record, we're on cause number GN 24-001696. This is a 2.6 assignment case, although this court is currently on the family docket, since it's been specially assigned. We are here with you on a civil case. We are here on a motion. I must admit, I've never seen a motion entitled this before. It is, or heard of one in my, over 30 years of litigation. Prior to taking the bench, we're here on a cross motion to enforce the local rules. So who set this motion?
Your Honor, I set this motion, Matthew Zorn, for defendants Hildreth, Symposia, Psychedelics Today.
All right, very good. Who else is here on behalf of defendants? Okay, who's here on behalf of plaintiff?
Me, Your Honor. George Greg Lake.
Okay. All right, Mr. Lake.
Your Honor. I'm sorry, Your Honor. Greg Noche and Liza Eoff for the USANA Promega defendants.
All right, so I'm trying to figure out, are you and Mr. Zorn, are there different defendants here, Mr. Zorn, that you're representing? And then we've got the USANA Promega defendants.
There are two different groups of defendants, Your Honor, and I'm happy to explain the difference and maybe giving the court a little bit of an orientation about the case before I explain the motion and the necessity for the motion in this case.
Yeah, that might be helpful. I must say, joint motion to enforce the local rule is a little unusual, as you all can imagine. So let me hear from Mr. Zorn.
Yes, Your Honor, it's an unfortunate motion, and I think it would be helpful if I just orient the court a bit about what this case is about, and then I will get into the substance of the motion.
Right.
And so in many respects, this is probably going to be a standard fair Texas citizens participation or TCPA case.
Mhm.
From our viewpoint, this is a case about plaintiffs' attempt to retaliate against all of the defendants for exercising free speech rights, and in particular, alerting to the public to a possible public health risk and frankly, fraud, Your Honor. And there are some unusual facts to this case. There are two groups of defendants in this case. So there are the Usona Promega defendants, and then there are the republisher defendants. And I'll explain the difference in just a moment, but I'm here representing the republisher defendants, comprised of journalists, scientists, and social media personalities. Here's the gist of the case. The plaintiff, the Church of Sacred Synthesis, says it has a sacrament that has a molecule in it called silomethoxin that it distributes to its members and that its members use religiously. The church not only makes this substance and distributes its sacrament to its members, but it also offers the sacrament for sale on a website. In a marketplace, for example, at thesacredsynthesis.com/marketplace, you can buy a sacrament.
Whoa, buddy. I don't really need you to be giving everybody the email ad or what was it again? Sacred Synthesis store? Something or other. Interesting.
Bundle for $145. You can buy 30 sacrament capsules for $100, or you can buy a chocolate bar that has some sacrament in it for $65. A couple weeks ago, the church had a Memorial Day sale where you could get sacrament for 15 or 20% off. Now, what this case is about is the Usona and Promega defendants obtained one sample of the so-called sacrament. They tested it, and they did not find any silomethoxin in it. Instead, they found psilocybin, which is the active constituent in magic mushrooms, which are controlled substances, Schedule I, under both federal and Texas law, which means they're illegal to possess, use, consume, and so forth. Then the Usona Promega defendants published an article on the testing that they did, explaining the results to the public. And I would just alert Your Honor, nobody that's tested the sacrament has, with any level of scientific rigor, has found any silomethoxin in the sacrament at any point in time. And I need not belabor this point. Basically, in certain respects, by all credible proof, the church is selling magic mushrooms online. Now, in the case of the Promega Usona defendants, it studied the sample and published that result in a scientific journal online. Some of the other Promega Usona defendants, including Promega itself and its CEO, appear to have absolutely nothing to do with this case and were simply brought in by plaintiffs for reasons I cannot explain. In the case of my clients, the republishing defendants, they essentially wrote articles or commented on the Usona Promega. It's not even Usona Promega, it was just an article written by two of the defendants in that group. And so their acts range from basic journalism to opinion and criticism, calling into question the church's practice. And so very shortly, Your Honor, the defendants will be filing a Texas Citizens Participation Act motion asking this court to dismiss the case because, among other glaring deficiencies in plaintiff's case, there's no credible evidence, let alone clear and specific evidence, to substantiate the existence of silomethoxin in their sacrament. In fact, if you were to go to the Wikipedia page today, it would call that molecule hypothetical. Now, that intro is just to orient this court to some of the unusual facts of this case. And now I want to talk about the unusual motion that I brought to this court, because over the past several months, it's become clear to us that plaintiffs and their counsel have expressed an unwillingness to abide by unambiguous rules. And then when we bring that to their attention, they concoct reasons ranging from unreasonable readings of the rules to no harm, no foul for why the rules don't apply to them. So the present motion has to do with pre-motion conferences. Plaintiffs didn't confer with defendants before filing the motion. And to be sure, I discussed with plaintiffs' counsel the subject of the motion, which was a motion for substituted service, because I told plaintiffs' counsel that we would agree to waive service days before they filed the motion. And so there was resolution of the issue. And I said, just give me a couple days, I will get the papers in. Your Honor, I had 2 depositions in very large matters and had the affidavit right in front of me, and I was ready to file it. And plaintiffs went ahead and filed their motion anyway, saying nothing of the fact that we agreed to waive service. And then in subsequent correspondence simply misrepresented what had happened between the parties. And then in their response, the court can see that their interpretation of Rule 2.2 is that pre-motion conferences only need to happen after a hearing is set on a motion, which is completely contrary to the text of the rule, which says that all non-dispositive motions require a certification that the parties have conferred. And the reason why is fairly straightforward, which is to avoid having to bring needless motions to the court. And I should note, Your Honor, that plaintiff's motion was sort of the archetype of a needless motion because, again, we agreed to waive service, so there was no need for substituted service. Now, that isn't the only reason why we have brought that to the court, because this is not proving to be an isolated incident. In fact, there are more serious violations of rules that we have put in our reply brief that I think it's important for the court to know. One of them is plaintiffs insist in their response that my clients weren't officially represented. That's a phrase in the response by me, even though I expressly told their counsel orally and in writing that I represented them, two of the defendants. Knowing that my clients were represented by me, plaintiff's counsel contacted my clients directly without copying me on the correspondence. Plaintiff's counsel knew they were represented by me because I told him, and they went behind my back and talked to my clients in an email.
Oh, that's a no-no. That's a definite no-no. I am intrigued by this case. I'm intrigued. He's making quite eloquent arguments. Allocution at this point. Don't creed frame, computer. Let's continue. Also, actually, just before we continue, this reminds me of, there was this like pre-legalization sort of landscape of, no, it's not DMT, Vicky. They already tested it. They said that it was magic mushrooms. So it's definitely not DMT. And what is interesting here is, to me, like in pre-legalization, the cannabis industry, there were certain organizations that sold items online, t-shirts, art prints, cookies, and along with them, you received a gift of marijuana. Now, they were sort of getting around the selling drugs feature by selling a small art card that, you know, you ordered along with your half ounce of weed and paid the same amount that you would for a half ounce of weed. So it's interesting to me, you know, when people try and find loopholes like that. I think that is what law is for, what they, you know, pushing boundaries, you know, testing different things. It's important. I also don't think that, yet again, magic mushrooms, I don't think are nearly as dangerous as alcohol, and yet very much more regulated in some senses and illegal. So I just think it's, I don't don't know. It's hard for me to like think that a government really cares about people and the drug policy without also restricting alcohol. And I'm not really for restricting alcohol. I'm actually for legalizing everything. But anyway, let's continue.
More concerning, in effect, it is as part of what appears to be a fact-gathering operation to complete service, plaintiff's counsel impersonated a fake individual and contacted the USONA, one of the USONA defendants, USONA. And this is beyond dispute, Your Honor, because there's a recorded voicemail of plaintiff's counsel purporting to be a person named G, contacting them to, I don't even, to donate money to them. But this was one day after plaintiff sent a demand letter to USONA. Plaintiff's counsel calls impersonating an individual named G, and then also sends a written communication where plaintiff's counsel purports to be a Roger Growing, and then sends contact information with an email that plaintiff's counsel's email, and that's in our reply brief. It's in a footnote. And then when we confronted plaintiff's counsel with, frankly, these unimpeachable facts, plaintiff's counsel floated conspiracy theories like his phone being hacked, and then simply stated he never misidentified himself, even though it's pretty clear that he did. And finally, there's now a motion on the docket for protective order. Plaintiffs seek discovery of a third party to get information on my anonymous client who offered criticism anonymously and wants nothing to do with this case or plaintiff's enterprise. I have no idea why. He's a social media, a small scale social media personality, and he doesn't want to be publicly associated with this case. And most importantly, I told plaintiffs we'd be willing to waive service if we could maintain his anonymity through the opening of discovery, and plaintiffs refused. So I have strong suspicion that plaintiffs have included him for improper purposes in this case.
And there really here lies the main issue with this. I don't think that it's appropriate to use the legal system to try and get naysayers of your product or your business or your church in trouble. I just don't like that. As somebody who constantly covers people's bad acts, it's not a good precedent to set that talking about something or writing about it is, you know what I mean? Like, opens you up like that, especially if it's publicly available information. That's awesome, Lori. I haven't seen it yet at all, so I'm hearing it all for the first time. Hi, Victoria.
Suffice to say, plaintiffs aren't entitled to discovery before third-party discovery before the discovery period opens, and yet it's another instance of plaintiffs believing that the rules don't apply to them. So in sum, that's what this motion is about, and it's an unfortunate motion, but it's one that is the plaintiff's unwillingness to abide by clear rules is starting to cause serious harm to people in this case already before it even gets off the ground. And so, you know, at this juncture, what we're asking is, going into this next phase of the case, at this juncture, we're asking for a court order that the procedural rules, that the parties need to abide by the procedural rules, because whatever their religious beliefs may be, belief is not a basis to not follow the rules. Like, the plaintiffs need to follow the rules, and so do we, and that is the purpose of today's motion.
All right, thank you very much, Mr. Zorn. Mr. Noskazi, did I say that correctly?
Actually, Your Honor, you did in terms of the Italian pronunciation, but our pronunciation in our family has changed over the years, and it's Noche.
Noche, all right.
Yes, thank
Well,
you.
I'm glad at least I got the Italian pronunciation correct.
That is correct.
Mr.
Thank you.
Noche, what do you have to add to what Mr. Zorn has provided, if anything?
Miss Eoff is going to address that, Your Honor.
All right, Ms. Eoff, what else do you have to add to what Mr. Zorn has just presented?
Mr. Zorn has adequately explained what has happened with respect to our clients. We do have a motion on file to stay discovery because the discovery period has not opened. I can confirm that we explained the rules several times to Mr. Lake, and I believe he just had an outdated copy of the rules, and that's why there was some confusion. And so we're here to verify that what Mr. Zorn is correct as far as what's been going on, but this is his motion.
Thank you very much. All right, Mr. Lake, please unmute yourself and let me hear your views, okay?
Yeah, thank you, Judge. And I guess if you don't mind if I start out giving a little bit of our side of the background, leading up to this case and kind of what this case is about, and then
Right.
briefly address these local rule alleged violations. I'm an attorney in Texas, and another attorney in Texas is a good friend of mine, and we are what we would call entheogen-based religious practitioners. We claim protection under the Federal Religious Freedom and Restoration Act of 1993 and the First Amendment, and also the Texas Freedom and Restoration Act, I believe, of 1999. Which provides commensurate, and if you ask the Fifth Circuit, in some cases, possibly more protection than the federal counterpart. But anyways.
Well, Courtney, he is indeed the lawyer for a magic mushroom church, allegedly. Apparently, I should be careful about that. He looks allegedly high, allegedly. This is such a weird look for a lawyer, but if I was going to tell you, if I had to pick out of the 4 lawyers that we've seen on this case so far, which one of them didn't know the rules properly and which one was fucked up, it would be him. No offense, bud, but Church of Sacred Synthesis. Okay. And guess what? Again, I'm not against weed or magic mushrooms. It's just, I find this hilarious. Like, in Texas of all places, is this really where you would run that thing? Like, I could maybe understand Washington. Also, just because are you allowed to? I thought religious exemptions, you don't get a religious exemption to the rules of court. That's not how that works.
We ran across, and my partner had been on a very long spiritual journey to find a molecule like silomethoxin. And he came across some literature from a very respected, but not with us anymore, chemist named God, his name Shulgin, Alexander Shulgin. Anyways, Alexander Shulgin proposed if you put on a cow patty with hallucinogenic psilocybin mushroom substrate growing in it, 5-MeO DMT, 5-methyloxyl dimethyltryptamine, which are these are all 3 together are controlled substances. Silomethoxin is not a controlled substance. Now there are residual amounts of psilocybin and psilocin left over in our sacrament. Now, when we first began our church way back in 2020, we did not immediately open it up to the public. We actually went and served a little bit over 1,200 people who all gave the same feedback. No negative health reactions. That was our main concern. And then 2, that there was a absolutely unique effects profile from these mushrooms from any other mushrooms that these very experienced people have created. So in September 2022, we decided we went public with the church. Despite, now, yes, it is a lot easier to get sacrament from our church, but that is more or less a function of what has been caused by these defendants.
Sorry. Okay, so it's not DMT, you guys. What he's talking about is silomethoxin is called 4,05-MeO DMT, but it is not DMT. DMT is just a abbreviation that they're using, but they're not talking about DMT, the dream molecule that that most people would be referring to. Even when he says DMT, it's part of the chemical name of that silomethoxin that he's talking about. And I think the main issue, they didn't say the issue was the DMT. They said that it was psilocybin. So, and he's just admitted that there was trace amounts of psilocybin in the sacrament still. So, I don't know. I'm sure he's referring to the I guess different compounds. I mean, he sounds like he's talking, it's pseudoscience to me. Sounds absolutely like pseudoscience. So, allegedly. But it's not like DMT in itself. First of all, I don't think you can eat DMT and have an effect of it. I do believe that you have to inhale it. And it has to be heated to a certain temperature. At least that's what it was when I did it. Anyways. Ooh, BLT sacrament sounds beautiful.
Within September through April of 2023, we saw significant growth. And I don't know if that upset the USONA defendants or how we came on their radar or of any degree, but we had been making strides because part of my clients, the church's liturgy, is this idea that science and religion and spirit are not neatly compartmentalized things, and that, especially through the study of psychedelics, we're starting to realize that, these two things overlap in many ways that we don't quite understand. And so it's part of our religious practice to further understand the interrelationship between those two types of dichotomies. And so, yeah, so anyways, our plan was, once we get up and running, we get membership in. We had about 2,000 members whenever this happened. We were doing really well. We were bringing in almost $100,000 a month in membership fees and sacrament.
I'm sorry, sir. I already looked. You're listed as a nonprofit church. So why would bringing in $100,000 a month be really good? That's so weird. Weird. I think it would be even funnier if there wasn't. See, what I thought the scam was going to be was that there was nothing in the mushrooms. They were just mushrooms. Like, wouldn't that be hilarious? Like, they claim that there's silomethoxin or whatever in it. There ain't that in it, and there's nothing illegal in it either. Like, that I would love, because that isn't really illegal. That would be where the win would be. You can't sell illegal drugs and be like, wow, we make so much money doing this. Like, dude, you can't do that.
Cells and but at that time we had not had enough money to save up to get our own testing facility, because as you can see from what's happened in this case, you can't just go to any willy-nilly person and ask for a test, to test your stuff and trust that what they're going to come out with is truthful. And what we found out probably about 2 months before suit was filed here was that if you test our sacrament with water, unlike methanol that USONA Promega did, again, and Matt was right, this is kind of there is no reference sample currently existing for this molecule, but USONA did make a guess at what the weight would be. And when we tested our sacrament with water consistently every time, we're pulling up a molecule with that exact same weight. And so we are in the process of creating the NMR reference sample to absolutely confirm 100% that there is silomethoxam in our sacrament. And I will say this before I turn to just real quick and address the local rules, is that I have a billionaire client that is in Nebraska that was invited to USONA Promega facility and was told some things that seemed to indicate that they knew before they published this article that they knew that this was not the 100% truth. But we will prove that in court. Don't take my word for that. That's just something I'm throwing out there. But with that being said, look, on the local rules, I did maritime litigation in Louisiana for close to 4 to 5 years before I completely switched over to doing this. I had never had to single-handedly deal with so many defendants at one time to try to get them served in such a short timeline, like a defamation claim with a 1-year statute of limitations. I did the best I could. I thought that I was really just following through with my due diligence. With Mr. Zorn, I've known Mr. Zorn. We've had a prior relationship. And I consider us to be friends. And he just, it kept saying one day, give me a couple more days. We're going to get this. And there's a lot of republishers here. So, his claim to represent all the republishers. But if you ask him one day if he represents Gordo Tech, and if I can get, instead of having to subpoena, a Patreon to get his anonymous information, I will be filing a motion very soon because I just amended my Second Amendment petition to basically include constitutionally sufficient evidence to create a prima facie case against Gordo Tech that would basically give you the green light to give a order to compel Patreon to disclose to me, regardless of when the discovery period starts, because this is a third party. I'm not even really sure how applicable this new third party rule, and I was mistaken at first, and I do apologize to everyone on the USONA side for being mistaken about the rule. I had an old version of O'Connor's, and I wasn't aware of the new amendments that had taken place. But now I am very well aware and ready to proceed that way. Lastly, I do. Unfortunately, this has caused me a lot of stress. My normal work plus taking on this litigation. And I had a couple seizures over the course of about 3 weeks. And I honestly do not remember placing these 2 phone calls to USONA. My wife tells me that I did make the one with and identified myself as G.
I'm sorry, what? What? Sir, I should have had my excuse counter out here, apparently. You had seizures? First of all, are you taking that sacrament? You want to be careful on that, allegedly. Secondly, what? Thirdly, your wife can confirm? First, does that mean that you were talking with your wife about private information, like the case, that you're not supposed to? I'm very, very perplexed now. And then this is all just fucked up. This is fucked up. Also, yeah, the YouTuber, please, I don't like that. I don't like searching for YouTubers that are, especially small scale ones. Like, it's a different thing if you have millions of subscribers. No, I know the wife confirmed he did make the calls, but how did she know that he had been accused of making those calls and would contact and would confirm that? Only if he asked her. And so he would have had to ask her specifically, like, somebody's saying that I made this call in this case. Like, there's a whole problem here. That's a whole problem. You know? The attorney can't contact his wife to see what he said at home. That doesn't work. He could subpoena her, maybe, but isn't there like spousal privilege? I don't even know. The whole point is, it screams weird to me. Remember that case we had in Kansas where the wife had, or not the wife, the prosecutor, Jill Gillette, was, there was a problem. Somebody kept going into her boyfriend, and he worked at a tire shop or something like that. And she just kept claiming the entire time, he is not part of my job. He won't know what you're talking about if you talk to him about it. I don't talk to him about work. Like, it's weird to me that he just said, oh, my wife confirmed that I made this call. What?
You know, why I did that, where I was mentally when I did that, I do not know. I apologize. It will never happen again. As far as the other one is identifying myself as a Roderick or Roger or something, I don't have any record of it. My wife does not seem to recall me making that phone call. But she did hear me call them, and what we were doing, we're seeking better service information to get them served, is what was the cause of the matter.
All right, very good. Thank you, Mr. Lake.
Yes, ma'am.
All right, so I've heard now from Mr. Zorn with the republisher defendant. I've talked with Ms. Eoff, who says that she is going to rely on the arguments made by Mr. Zorn at this time. I realize there's some other motions, but they aren't set today. And I've had the opportunity to hear from Mr. Lake, who, are you currently licensed in Texas, or are you pro se?
I'm currently licensed in Texas, and I will say, due to my physical ailments, we have been able to, I think by the end of this week, we'll have a firm out of San Antonio basically taking lead counsel for us in this, because there might be a chance I might have to be a witness. So, you know,
Right.
in case that chance comes.
Well, I think, Lori, we have to give the credit where credit's due. The judge aired the case on her YouTube channel. But yeah, I'm sure there's lots of channels that have covered it by now. I was sent this, like I said. This is super bizarre. Super bizarre.
We'll have someone there who can take and you know, there won't be any issue, and we can keep this thing going smoothly.
Mr. Lake, I would strongly recommend that. I think it's very difficult to represent an entity that you have strong beliefs about.
It is.
It's hard to keep your emotions out of it, and that can really sometimes not benefit a party in the courtroom. So I would encourage you to get that law firm that you mentioned, or any reputable firm, to
Mhm.
help you with the case. So
Yes.
today we have to take what we've got. All right, so Mr. Zorn, let's go back to you. So it looks to me like what you're asking me to do is to sign an order that says follow local rules, but you're basically already an order. Is that what you're wanting? I mean, or is it more the type of thing where you need me to hold them in contempt? I guess that's the question. What do you want from me today?
Your Honor, we do not want an order, a contempt order today.
All right.
The operative word being today, that is not what we want. We do not want sanctions. We do not want any affirmative punishment today. But we do believe a court order saying that the parties need to abide by the local rules would then be a court order. And then going forward, the parties would need to adhere to the rules and maybe if it continues, again, a very unusual motion, but as I've narrated to the court, there have been some serious events that frankly just need to stop. My clients cannot be contacted by Mr. Lake without going through me when he knows them to be represented. That is my main concern at this juncture. And so, and similarly with the procedural rules, it can't going forward. It can't be the rules don't apply to us. So that's all we're requesting today is a court order saying that the local rules apply to everyone, and going forward, there could be contempt penalties.
Yeah. Well, of course they do apply to everyone. They already apply to everyone. I can't really issue an advisory opinion.
Well, then, Your Honor, we would ask that simply the court note that the local rule was violated in this case, but we are not asking for a penalty or a sanction of any kind.
Right.
The motion was resolved successfully, but we would like a finding that the local rule was violated because plaintiffs did not confer on the motion.
All right. So I can't issue an order that says in the future, follow the local rules. That's already the rule. Now, what he's saying, Mr. Lake, and when I ask him about contempt, and I think Mr. Zorn is trying to keep he's trying to pour water on this fire rather than gasoline, which I do appreciate very much. I wish that more people would come into court with that attitude. That typically those local rules they already have the force of a court order. And if you violate them, you violate them. And so if you continue to violate them, they can come in and on a motion for contempt, which can include fines and jail time. And I know those are things you don't want because it would take you away from the Church of Sacred Synthesis, and that's what you do not want. So, but Mr. Zorn has pulled that punch, as they say. He's not going to do that. I cannot I can't sign an order that says in the future, follow the local rules, because that doesn't add anything. It's advisory in nature. Mr. Zorn, if you want to draft an order that says there has been a violation of the local rule, and I find it, the parties are not currently seeking contempt or monetary sanction, I would sign an order like that, but be specific on how it was violated. Okay.
Thank you, Your Honor.
All right. So I'm going to go on and grant relief to Mr. Zorn today. Mr. Lake, though, please keep in mind, this is, as we used to say, it's a shot over the bow. Meaning it's kind of a warning. It's a warning volley that's saying to you, you got it. I understand what you're saying. You've had certainly some very serious health issues, it sounds like to me, and I hope those are resolved. Seizures. I'm concerned about your well-being with that, sir. I know you have had experience practicing maritime law in Louisiana, as you've explained to me.
Mhm.
And I know that you're in the process of looking for a law firm to handle the case. I really suggest you do that, because the thing is this, Mr. Zorn, if he hadn't come in and just fired the shot over the bow, could have gotten you, he could have made you all pay some attorney's fees. I know you want that money for the church. And he could have come in here and held you in some personal contempt. And that would take, not only are you a person with some health issues, but you're also, as you've pointed out to me, extremely busy with your church and this litigation. The last thing you need is for us to impose some sort of jail time for violating local rules. Now, I'm not saying we would do that, but it's in the basket of the toolbox that we have for these types of things. So let's take Mr. Zorn at his word. He's going to draft an order saying that there was a violation of the local rules. He's going to explain it in the order. He's going to say that there's no contempt being sought and no attorney's fees. I'm going to sign that. But Mr. Lake, please, please, in the future, just review those local rules. They're online. They're very easy to find. So just find those Travis County local rules and read them and abide by them. Do not contact people. I know you said you don't remember it, and I'm going to take you at your word on that. But if your wife hears you picking up that telephone when you're in an altered state of mind because of health issues or what have you, please, please say the court has ordered me not to do that. You all figure out a way for her to nicely ask you to not make that phone call and to wait till your head is cleared. And then I want you to contact these attorneys directly, not the clients. Okay?
It was my fault, Your Honor. I, the statute of limitations was running up real quick. And
Okay.
I was just impressing upon her how, we need to get this filed and served ASAP, like just ASAP, ASAP, ASAP. And, even she was kind of getting a little bit frustrated with Mr. Zorn a little bit whenever he was kind of going back and forth a little bit. And she was like, just follow the motion, and I think we all learned a little bit now that, if Mr. Zorn tells me that he's representing somebody, even though they haven't been quite served yet and it's past the statute of limitations, I guess I just got to kind of rely on what he says.
Well, they're filed and served. I mean, I don't want to tell you how to do your lawsuit, but I think, if you got it filed in a timely fashion and served within a reasonable time, you're probably okay. But I have not looked at the statute that applies to you. So
Right.
you need to get, too wound up on that. Now, here's what I'm going to ask you, Mr. Lake. I hear what you're saying. Please, when we get off this call, go online and find the Travis County local rules and read them. In fact, Ms. Guardiola, is it possible for us to put, or Mr. Agidi, possible for us to put a link to those rules in the chat box so that we don't have this come up again?
I've got them right. I was reading them prior to our hearing today, Judge.
Good.
I'm going to become an expert on them by the end of the litigation.
That's what I like to hear. All right, so let's do that. And again, tell your wife, if you start to see me when I've had one of these, bad health spells with seizures or whatnot, please don't let me make those silly phone calls to people who are represented. You need to, those calls, all of them now, you need to go directly to Mr. Zorn or to the other attorneys on this call if it pertains to them. Represented people cannot be contacted directly. That's why we have to have it with the attorneys. Okay. All right. And when you have someone call up and say, hey, can we make an agreement? If you're amenable to that agreement, which the rules require you to do that first, then that's done. That's a done deal. All right. We don't go back on that. So, all right, folks, I don't know if there's anything else I can do for you. Mr. Zorn, please draft that order. Do not make it advisory in nature. And I will sign it and send it to Mr. Lake. And Mr. Lake, you put that right where your wife can see it. And you say, look, that judge said this is a shot over the bow. In the future, we've got to be a lot more careful, or we could end up having to pay attorney's fees. We could end up being fined. Bad enough violation, we could even end up in jail. And that takes you away from your duties with the church. And that's what you don't want. Okay?
The attorneys we spoke with, real quick, Judge, the attorneys we spoke with real quick yesterday, they were just blessed that we have one judge through this whole thing. They said, look, because I like to research and write. I'm a First Amendment expert, and I like to research and write on First Amendment stuff. So, all I'm going to be doing from now on is just sitting back, research, writing, doing some depots and some discovery, and only talking to the parties with their attorney present.
All right, that sounds good. And to the degree that you can take on more of an assistive research role than being the face of the litigation, in other words, at depositions and things like that, I would really encourage you not to do that. I think when we have to show up as attorneys asking questions in court or in deposition, because as we always say in deposition, it's just as if the judge and jury are right there when that's occurring. To the degree that you can step away and hand off those duties to the San Antonio law firm you mentioned, I think that you're going to find that your time here is a lot easier and that we won't have Mr. Zorn.
I would not take him as a client. allegedly. Also, Lori, I'm laughing. I didn't mean to come across rude. It's tough sometimes. There are so many court channels these days, which is great, that I sometimes cannot figure out who, or I just literally don't have time to watch different channels. And so sometimes I had a huge giant list of things to do today, and I crossed off like 78% of it, which was very good for me. And so, but what that meant is that I didn't get to scope out a lot of other channels. So don't take it the wrong way. I just like people to know that, because I haven't seen any part of this. I think the judge is being overly nice to him. I think that but she's also basically saying specifically, like, you should not do this, which would be that would hit me in the heart if the judge said that to me and I was a lawyer, but I'm not a lawyer, obviously. La, la, la.
Mr. Nosage and Ms. Eoff bringing you into court on this stuff. So, but I understand it. As you've made very clear, you have a high degree of expertise in these areas, and I have no doubt that you will be research and writing. I just kind of let that law firm take the lead in court in any kind of witness or deposition. Okay. The other thing, Mr. Lake, I want you to be aware, it looks like there is going to be a motion filed potentially by Mr. Zorn, kind of questioning the underpinning of this lawsuit. That's something he's entitled to do. The other thing I want you to be aware of is you might get some disclosure requirements. Please look at the Texas Rules of Civil Procedure on Disclosures.
Okay.
If you get discovery coming in, please look at those discovery rules. Now, sometimes in discovery, they ask us to turn over things that we do not want to turn over. The law still requires you to get those at least to your attorney. Make sure that no matter what happens, that you put a number at the bottom of every single page, sequentially from the first page all the way through to page 1000. We used to call them Bates numbers, but we don't call them. They're just numbers, sequential numbers. And that when you respond to that discovery, that you write in response, for instance, page numbers 0005 through 00025.
Okay.
If you do that, it'll make things a whole lot easier. If you just, I have a big pile of cases on my desk, but if this were a batch of discovery and I just took all this in an envelope and sent it to them, that's too hard to deal with, and that's not what the rules require. So on the bottom of each page, put it in your Adobe program. It'll put a number on it. And then when you respond to those questions, make sure to put that number in there. Now, when we hang up this call, thank you for looking at the Travis County local rules. Go look at the rules on disclosures, request for production, and interrogatories and depositions. Familiarize yourself with those. If for some reason the San Antonio firm does come in, you'll have more productive discussions with them. If they don't come in, then we hopefully won't end up here again on a motion that honestly we didn't really need to come in. Okay? All right, Mr. Lake.
99% they'll be coming in. So we'll
Okay.
hopefully by the end of this week, next week, have them as counsel, and we can just.
Okay, have them make an appearance so I can see them when they come in.
I will.
All right, very good. All right, Mr. Zorn, anything else?
No, Your Honor. Thank you very much. We appreciate the hearing.
You're welcome. Mr. Nosage, anything else?
Nothing from us, Your Honor. Thank you.
Mr. Eoff and Ms. Eoff, anything else?
No, Your Honor. Thank you for your time.
All right, you're welcome. All right, thank you all. It's good to see all of you. I wish you a very happy rest of the day, and we'll look forward to seeing you again in the future. You may be excused, okay?
Been a pleasure seeing y'all today. Thank y'all.
Greg, dude, not the time. Pleasure seeing you all for that public spanking that I just received from the judge, who told me indeed to look up the basic rules of the job that I am supposedly proficient at. No. I think that is possibly one of the most embarrassing hearings for a lawyer I've ever seen. I hope he's high on mushrooms, allegedly, because if he watched that sober and didn't pick up on that, then I would be worried about where he got his law degree from. I'd be questioning those things. Allegedly, Greg, it's all alleged. Also, did you notice how he didn't even, like, at the beginning when he said his name, he didn't say Greg first. It's weird. Anyways, I hope that everybody has had a wonderful day. I know it was a bit of a short one and early, but because I'm going to go have tacos for Thursday dinner, and I got to make it. So thank you so much for being here. Remember that I love you. I am proud of you. And, oh, last thing. I actually really love it when different channels cover different cases. I want to point that out. I would love it. Like sometimes I'm like wish that other big channels would pick up some of the cases that we cover. And then sometimes I'm the one that's coming to the table at the end of the day. But I really like that you guys can go and see different cases. I do that with different channels sometimes. And like older cases when I'm listening to them. But I appreciate each and every one of you. Happy birthday to Music 72 once again. And now I'll do it properly. Remember that I love you. I am proud of you. And I will see you in the next video. Bye.
One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time.
Thank you so much. Very, very kind of you. Coming in last moment, dropping a membership. Thank you so much. And I hope that you have a wonderful day. Okay, I love you. Bye.